Peter Hugh McGregor Ellis, the 30th of March 1958, the 4th of September 2019, was a New Zealand childcare worker who was convicted of child sexual abuse. He was at the center of one of the country's most enduring judicial controversies, after being found guilty in June 1993 in the High Court of New Zealand on 16 counts of sexual offences involving children in his care at the Christchurch Civic Creche and sentenced to 10 years imprisonment. He maintained his innocence until his death 26 years later and was supported by many New Zealanders in his attempts to overturn his convictions. Concerns about the reliability of the convictions centered on lurid stories told by many of the children and the interview techniques used to obtain their testimony. In 1994, Ellis took his case to the Court of Appeal of New Zealand, which quashed convictions on 3 of the charges but upheld the sentence. His conviction and sentence were upheld in his second appearance before the Court of Appeal in October 1999. In March 2000, former Chief Justice Sir Thomas Eichelbaum was appointed to conduct a ministerial inquiry reviewing the children's evidence. His report upheld the guilty verdicts. The same month, Governor-General Sir Michael Hardy-Boys rejected Ellis' third bid for pardon on the advice of Justice Minister Phil Goff, who was satisfied with Eichelbaum's finding that Ellis had failed to prove his convictions were unsafe. Ellis refused to attend parole board hearings while in prison because he would have to confess to the crimes in order to argue for early release. He was released in February 2000 after serving 7 years in prison. 2 books and numerous articles have been written about the case. After his release, Ellis continued campaigning to clear his name. In 2019, 19 years after he was released, he appealed to the Supreme Court to have his conviction overturned, but died of cancer before the appeal could be heard. The Ellis case was one of several similar high-profile child abuse cases around the world in the 1980s and early 1990s. It has been mentioned as a cause in the decline in the number of male teachers in New Zealand schools. Personal life: Ellis was the eldest of 4 children. His parents were teachers who separated when he was 9. He left school in 1975 to take up tobacco picking in Motueka. After 2 years overseas, he returned to New Zealand. He then had a part-time job in a bakery in the 1980s, which eventually became full-time. When he left this job and applied for unemployment benefits, authorities discovered he had received dole payments to which he was not entitled. He was prosecuted and convicted in 1986 of misleading a social welfare officer and sentenced to 80 hours community service. Ellis carried out his community service at the Christchurch Civic Creche. His supervisor, Dara Rainfeld, later reported that Peter provided some hilarious puppetry shows, one of which we had to abandon as staff and children got out of hand. Ellis became a relieving worker, and Rainfeld's next monthly report said, "Peter Ellis has fitted in extremely well and puts lots of energy into program planning. Fantastic team spirit." Ellis's pre-sentencing report said, "The overall picture gained of Peter Ellis is that of an outgoing, uninhibited, unconventional person given to putting plenty of enthusiasm and energy into his work and social activities, sometimes to the point of being risque and outrageous." Before his imprisonment, Ellis had sexual relationships lasting for periods of 2 to 5 years with both men and women. He told Linlay Hood, "In a relationship with a woman I was, for want of a better word, bisexual, and with a man I was monogamous." When working for the Civic Creche, Ellis was described by Hood as blatantly homosexual. In July 2019, Ellis was diagnosed with terminal cancer. He died on the 4th of September 2019 while appealing his conviction at the age of 61. Investigations. Background: Ellis loved animals and kept rabbits, cats and dogs as pets. His difficulties began when a mother, who was a social worker and a self-claimed victim of sexual abuse, bought a black puppy from him. Ellis showed her 4-year-old son, who attended the creche, how to distinguish the puppy's gender. A few months later, in November 1991, the mother alleged that her son said he didn't like Peter's black penis. His mother, who had written a handbook on sexual abuse, concluded her son had been sexually interfered with. She made a complaint to the creche in November 1991. After a brief investigation, the police decided there was no case to answer, but Ellis was suspended from work. The mother then withdrew her son from the creche and enrolled him into a different Christchurch daycare center. Shortly thereafter, she alleged a male worker at the second creche had also abused her son. The police investigated and again found no evidence to support the allegation. ERL report Ellis was extremely popular with children and parents at the creche. In the week following his suspension, inspectors from the New Zealand Education Review Office spent a full week at the civic creche observing its daily operation. The office subsequently issued a highly favorable report, stating that the staff ensure personal needs are met with warmth, care and consideration. The children appeared happy, inquisitive and sociable, and that they, the children, have high self-esteem. Second police investigation. Even though police concluded no abuse had occurred, some parents started asking their children about what went on at the creche and then shared these stories with other parents. The Department of Social Welfare was called in to conduct formal interviews with many of these children. A social welfare psychologist, Sue Sidey, initially revealed that there were 6 children for whom she felt there were grounds for concern, although the children made no disclosures of any indecent touching by a creche staff member. More parents became concerned that something must have happened. As the social welfare interviews continued, claims about bizarre sexual abuse incidents began to surface. A meeting was held at the creche attended by staff members, a group of concerned parents and representatives from the social welfare department. In response, the police reopened their investigation. Altogether, at least 127 children were interviewed. Some detectives believed that up to 80 had been abused. Smart report. In addition to interviews conducted by Sue Sidey, the Christchurch City Council, which owned the creche, requested that psychologist and sex therapist Rosemary Smart review the management practices at the creche. Even though Smart's report was completed nearly 12 months before Ellis' trial, she seems to have assumed he was guilty. Although the word "alleged" crops up occasionally in her report, severely incriminating circumstantial evidence is presented as factual. Smart suggested that female staff may have been involved with abuse at the civic creche, and her report helped convince investigating officers of the women's guilt. She quoted research by the New Hampshire sociologist David Finkelher, whose 1987 book, Nursery Crimes, became the source for American believers in ritual abuse occurring in creches. Finkelher's work has since been discredited. Arrest of 4 female staff. Smart's report was completed in July 1992 and a copy was given to police. Detectives said her report was central to their decision to investigate 4 of Ellis's female colleagues at the creche. Their houses were searched for everything from pornography to babies' bodies. Nothing was found. Ellis' mother was suspected of being involved and accused of administering drugs to the children. The 4 female staff members were arrested on the 1st of October 1992 amid considerable televised publicity. At depositions they faced 15 charges that included sexual violation, indecent assault and 1 charge of performing an indecent act, having sex with Ellis in a public place. The charges were subsequently dropped when Judge Williamson concluded the publicity meant their chances of a fair trial would be prejudiced by their association with Ellis. Although the charges were dropped, their careers were ruined. Accusations. Ellis was accused, among other things, of sodomizing children, forcing them to eat his feces, urinating on them, suspending them in cages, taking them on terrifying trips of abuse through tunnels, ceilings and trapdoors. Other allegations included children being forced into a steaming hot oven or buried in coffins. One boy claimed he had his belly button removed with pliers. Allegations which emerged later as the interviews progressed included Asian men dressed as cowboys, Masonic lodges, cemeteries, the Park Royal Hotel and private houses far from the creche, and the notorious Circle incident where Ellis and his co-workers supposedly took a group of children to 404 Hereford Street on the other side of town and made them stand naked and kick each other while the adults danced around them, alleged by one parent, was the sacrifice of a boy called Andrew. No child was actually reported missing by anyone involved. The police arrested Ellis on the 30th of March 1992, charging him with the first of what would eventually be 45 counts of sexually abusing 20 different children at the creche. By the time the case went to trial, the Crown had reduced the number of charges to 28, involving 13 complainants. Some charges were dropped because the Crown prosecutor, Brent Stanaway, did not want to put the more bizarre claims made by some of the children before a conservative Christchurch jury. Trial barristers Rob Harrison and Siobhan McNulty represented Ellis. Brent Stanaway and Chris Lang appeared for the Crown. The offenses were alleged to have taken place at unspecified times and dates between the 1st of May 1986, 4 months before Ellis started work at the creche, and the 1st of October 1992, 11 months after he left the creche, and a month after the creche was closed. Hood, 2001. Defense counsel Rob Harrison wanted the jury to see the children's videotape testimony containing the bizarre allegations, as he believed they would cast reasonable doubt on the more credible testimony. However, Justice Williamson ruled that these tapes were not relevant. In a city-possessed, Lindley Hood observed, Judge Williamson's rulings before and during the trial meant Ellis' lawyer Rob Harrison was effectively hamstrung. The jury did not get to hear the most bizarre of the children's allegations, but did learn of the highly prejudicial but irrelevant conversations Ellis had about unusual sexual practices between consenting adults. Psychiatrist Karen Ellis was the prosecution's expert witness. She also supervised the social workers conducting the children's interviews and advised the police about how they should conduct their investigation. She testified that the complainants were credible and their behavior was consistent with sexual abuse. However, in August 1992, she wrote to the police saying that 2 of the complainants had undergone highly leading questioning from their parents. Her letter was not disclosed to Ellis's defense, and Ellis did not mention any concerns about the 2 children's credibility at trial. Psychiatrist and defense expert Keith LePage said that none of the behaviors described by Ellis were specific to sexual abuse. LePage said that in his experience, children and adults who had been abused usually expressed distress when recounting their experiences of abuse. The complainants showed little or no distress when describing acts of abuse during their interviews and when later testifying in court. LePage also testified that children couldn't remember events experienced at a very young age when there was a long delay between the event and the attempt to recall it. Children couldn't remember events, even traumatic events, that had occurred at 2 or 3 years of age when there was a long delay. He claimed the alleged abuse at the creche had occurred when children were at these ages. Conviction. In June 1993, Ellis was convicted of 16 counts of sexual offenses involving 7 children. The charges on which he was found guilty were that he had urinated on 2 children, made one masturbate him, put his penis in the mouths of 3 of them, engaged in indecent touching of 3, and put his penis or an unknown associate's penis against the vagina or anus of 3. The following year he was acquitted of 3 charges involving the oldest complainant, who retracted her allegations and admitted her original statement was what her mother told her to say. Treatment in prison. Corrections officers who sat through the trial with Ellis did not think he was guilty and let that be known at Paparua Prison. As a result, Ellis was not subject to the kind of beatings that perpetrators of childhood sexual abuse often suffer when sent to prison. Creche closure. On the 3rd of September 1992, following discussions between the City Council, the Ministry of Education and Police, the civic creche was closed. In March 1995, the 4 female employees and 6 other former staff who had also lost their jobs were awarded $1 million by the Employment Court. This was later reduced to $170,000 by the Court of Appeal in September 1996. Reliability concerns. Moral panic. In the years preceding the first allegation of abuse against Ellis, there had been a number of high-profile child abuse cases in Christchurch involving highly suspect interviews of children, mistaken mass diagnosis of children, and other highly questionable claims. The case has also been linked with the daycare sex abuse hysteria, a moral panic that originated out of California in 1982 and that existed throughout the 1980s, and satanic ritual abuse. It has also been cited as a major cause in the decline in the number of male teachers in New Zealand schools. From September 1991, 2 months before the first allegation against Ellis, there was continuous publicity of sexual abuse and ritual abuse of children in the local press or in national media. On the 4th of September 1991, a Wellington sex abuse counselor, Anne-Marie Stapp, told the Christchurch Daily, the press, that New Zealand was fast approaching the level of ritual abuse awareness found in the United States. North and South magazine reported that it was common knowledge around town that various Christchurch police officers were hunting for a near-mythical pornography pedophile ring alleged to involve judges, Freemasons and prominent businessmen, though it was never found. On the 3rd of November 1991, the Sunday News quoted the police as saying that Satanism was rampant in New Zealand and linked to child pornography. 17 days later, a Christchurch mother rang Gay Davidson, the supervisor at the Civic Creche, to make the first complaint about Peter Ellis. When making his appeal to the Supreme Court announced in July 2019, Ellis' former lawyer, Nigel Hampton QC, said he wants the Supreme Court to take the moral panic of the 90s into account in its decision-making. Interview process. At least 118 children were interviewed as part of the second investigation into allegations of sexual abuse. Social welfare psychologist, Sue Sidey, conducted most of the evidential child interviews used at the trial, although she had no formal qualifications in child psychology. In December 1991, Sidey conducted a number of interviews with children which failed to turn up any statements consistent with abuse. Nevertheless, that month, she made a statement that Peter Ellis is not a suitable person for a child center, before any formal allegations of abuse came to light. However, as more parents became concerned, some children were subsequently interviewed up to 6 times and began making bizarre allegations. The children's stories were hardly ever challenged, no matter how fanciful their answers. If the answers were inconsistent or incoherent, then they would be asked again in more elaborate form until an acceptable answer was elicited. Specific questions were employed to elicit allegations that children had apparently made to their parents, contrary to best practice guidelines. The interviewers generally did not check with the children to find out whether their parents had said things to them about Peter Ellis or about the creche to eliminate the possibility of parental contamination. One mother even admitted in court that she encouraged her son to come up with new information by cuddling him, praising him and telling him how brave he was after he revealed more and more details of his abuse. Michael Lamb, a leading authority on the interviewing of child abuse victims, was asked to review the interviewing process the children endured. In addition to the problems caused by multiple interviews, he noted that there were substantial delays between the alleged events and the formal interviews, which were conducted up to 18 months later. Lamb wrote that during this time, the children were exposed to conversations with their parents, social workers and other children, and were likely to have adopted recently acquired information about the events in question. Stephen J. Ceci, a psychologist at Cornell University and an expert in children's suggestibility and children's courtroom testimony, also studied transcripts of many of the children's evidential interviews. In July 1995, he said the interviews were not conducted in accordance with currently understood interviewing principles. According to Ceci, it is impossible to distinguish between accurate and inaccurate allegations when children are suggestively and repeatedly interviewed over a long period. Ellis' sexuality. A number of people who were involved in the case believed Ellis was convicted because he was homosexual and was the only male worker at the creche. At the trial, he was portrayed as sexually deviant and perverted, which was somehow consistent with the makeup of a child molester. ACC involvement. One parent, Malcolm Cox, who had 3 children at the creche, suggested that some parents may have been motivated to make claims that their child had been sexually abused because ACC automatically awarded $10,000 to anyone claiming to have been abused. He said that he and his wife were visited by a council social worker with ACC claim forms and told, "We had to get in quick to claim the money because lump sums were being abolished." In the end, the Accident Compensation Corporation, ACC, paid more than $500,000 to about 40 parents of civic creche children. Generally, parents received a standard $10,000, but in cases where Ellis faced multiple charges relating to a single child, some parents claimed for each alleged incident of abuse. McLaughlin, 1996. One child's parents allegedly claimed 5 payments, while another claimed 4. According to North and South magazine, ACC didn't require a conviction before paying out. It paid up without so much as charges being laid in respect of some allegations. The police even wrote letters to ACC supporting compensation claims. Jury. A number of irregularities in the trial were publicized in a TV3 2020 television program which aired on the 16th of November 1997. The program alleged that the jury foreman had been the celebrant at the wedding of the Crown Prosecutor Brent Stanley 15 years earlier. It was also alleged that a female juror had had a sexual relationship with a co-worker of the mother of one of the children involved. The program also put forward statements that most of the children who made allegations of sexual abuse withdrew their accusations at various times during proceedings, but that social workers conducting the interviews treated this as a symptom of denial. Detective Colin Eade. The 2020 program also claimed the main investigating detective, Colin Eade, had a history of mental health problems. Eade told interviewer Melanie Reed he was burnt out before the case started and beyond repair by the time it was over. He left the police force in 1994 suffering from post-traumatic stress disorder. In an interview with Sean Plunkett on Radio New Zealand's Morning Report on the 20th of November 1997, Eade admitted that after the trial he had sexual relationships with 2 of the mothers involved in the case and that he had propositioned another mother during the course of the investigation when he was drunk. New Zealand First MP Rana Waitai, who was a former police commander with 31 years experience, said, "If half of what was on the 2020 program is true, Peter Ellis must immediately be released and hugely compensated for the devastation that has been done to his life." Appeals. First Court of Appeal 1994. The case entered the Court of Appeal in July 1994 led by Graham Pankhurst QC. A key aspect of the appeal was that the 7 children, whose evidence the jury accepted, had named 21 other victims, either as observers or participants. None of those 21 children confirmed any of the allegations. On the 4th day of the hearing, 28 July, the oldest child on whose testimony Ellis was convicted, and probably the most credible of the child witnesses, told her parents that her story was not true, that she had said only what she thought her parents and the interviewer wanted to hear. The Court of Appeal considered that it was not uncommon for child complainants to withdraw their allegations. The appellate judges believed the retraction may have been a case of denial on the part of the child and was grounds to overturn only those convictions relating to that child. The child has continued to maintain that she fabricated her allegations. Second Court of Appeal 1999. In November 1998, Ellis presented a second petition to the Governor-General seeking a royal commission on inquiry into his case, and either a free pardon or for the whole case to be referred back to the Court of Appeal. The Secretary for Justice sought advice from Sir Thomas Thorpe on the second petition. His advice concluded that the terms of reference should be expanded. In 1999 the Ellis case was referred to the Court of Appeal for a second time. Judith Bletcar, QC, appeared as counsel for Ellis, and Simon France for the Crown. Abletcar argued emphatically that the children's evidence had been contaminated by parental questioning and presented updated opinions on the dangers of multiple interviews, using anatomically correct dolls and suggestive questioning. Barry Parsonson, former head of the New Zealand Psychologists Board, was asked to write a report into the process used to interview the children prior to Ellis's second Court of Appeal hearings. Parsonson concluded that, given the conditions prevailing at the time, the level of parental contamination, and the extremely suggestive interviewing procedures, the probability of the proportion of fact outweighing the proportion of fiction must be very, very small indeed. The Crown presented the expert opinion of Constance Dahlenberg. The court concluded that they were not persuaded that a miscarriage of justice had occurred, but suggested a royal commission of inquiry could better examine some of the issues raised. Ellis immediately presented a third petition to the Governor-General. Petition for Mercy. In 1999, a retired High Court judge, Sir Thomas Thorpe, was commissioned by the Ministry of Justice to examine a petition for the royal prerogative of mercy lodged by Ellis's counsel, Judith Abletcar QC. She commissioned and supplied reports by experts that were based on selective information for Thorpe to consider. Despite the limitations of the reports, Thorpe considered they raised serious concerns that should be investigated further. He wrote that the interview transcripts revealed that on more than one occasion, one child claimed to have seen serious abuse committed against another child, but the second child denied anything happened. Thorpe said there was no evidence that the interviewers or the police did any cross-checking before presenting abuse allegations to the jury. He was also concerned that the more bizarre allegations made by children were not put before the jury, arguing that the jury had to see that the children were capable of outrageous and fanciful allegation. Thorpe stated that the central concerns were the claims of defective interviewing techniques, the risk of contamination of the children's evidence, and the exclusion of evidence necessary to a proper assessment of the children's reliability. He added that if the opinions of Barry Parsonson, Stephen Sussy and Justice Wood were found to have substantial support, it would be difficult to argue against the existence of a serious doubt about the safety of the petitioner's convictions. Eichelbaum Inquiry 2000. In March 2000, then Minister of Justice Phil Goff established a ministerial inquiry into the conduct of the interviews, headed by Sir Thomas Eichelbaum. This was undertaken in response to Justice Thorpe's report and ongoing concerns over the reliability of the children's evidence. In a later submission, ministry officials stated that the ministerial inquiry was intended to address specific areas of concern that might not have been seen to have been fully resolved by the Court of Appeal. The terms of reference required Eichelbaum to examine the relevant documents and seek written submissions from those who were involved in the case but not to interview anyone. He was also required to appoint 2 international experts to provide written reviews of the interviewing techniques that had been used to seek information from the children. He appointed Professor Graham Davies of the University of Leicester and Dr. Louise Sass, from London, Ontario, Canada. In his evaluation, Graham Davies wrote he would not pronounce on the reliability of individual children's accounts. Professor of Psychology at Auckland University, Michael Corballis, subsequently questioned the credentials of both these experts, asking of Dr. Sass, can she really be considered an expert? Released in March 2001, Eichelbaum's inquiry concluded that the interviews were of good quality overall, and that though excessive questioning by some parents could have led to some contamination, this would not have been sufficient to affect the convictions. Eichelbaum did not say how he determined the children's evidence to be reliable. In December 2007, University of Otago psychologist Charlene Hain conducted research which compared the standard of interviews conducted in the Ellis case with those of the Kelly Michaels case in the United States. Empirical analysis allowed Hain to conclude that there was a strong risk that the evidence of children who told of sexual abuse by Ellis was contaminated by the way the interviews were carried out, and that, contrary to Eichelbaum's conclusions, The standard of the questions in Ellis was not substantially better than those in Michael's. Francis's articles and Haney's research were cited in January 2008 by Ellis's counsel when making a renewed request that the Ministry of Justice establish a Royal Commission of Inquiry into the case, but Associate Justice Minister Rick Barker rejected this approach in March 2008. A further call for a commission of inquiry was made by former national MPs Catherine Rich and Don Brash and author Lindley Hood in November 2008, and the new Minister of Justice Simon Power said that the government would reconsider the issue. He later declined their request for an inquiry, on the grounds that Ellis still held the right of appeal to the Privy Council and an inquiry therefore could not achieve finality. Petitions for a Royal Commission. In June 2003, 2 petitions called for a Royal Commission of Inquiry into the case. The first, organized by then National Party leader Don Brash and MP Catherine Rich, had 140 highly prominent signatories. They included 2 former Prime Ministers, David Lang and Mike Moore, 4 former Cabinet Ministers, 26 MPs, a retired High Court judge, Lawrence Grieg, a retired District Court judge, 12 law professors, 12 Queen's Counsel, former Auckland Police Chief Brian Rowe, historian Michael King, psychology professors, professors from other disciplines, lawyers, child protection workers, psychologists, social workers, therapists and counselors. In August 2005, Parliament's Justice and Electoral Select Committee reported on 2 petitions relating to the Ellis case. The committee had several concerns with the way the case was prosecuted. It recommended several changes, although it acknowledged that changes had already been made to the way that children were now interviewed. It also suggested that the testimony of expert prosecution witness Karen Ellis would not be permitted if it were proffered now. The committee noted that the operation of the legal system in respect of this case did not inspire adequate public confidence in the operation of the legal system. A justice system should lead to certainty. In this case it seemed to increase the sense of uncertainty. However, the committee rejected the petitioner's call for a commission of inquiry, concluding that it was not practical to hold such an inquiry. In 2011, Ellis announced his intention to lodge a 4th petition to the Governor-General. Supreme Court 2019. On the 25th of July 2019, Ellis, aged 61, lodged an appeal to the Supreme Court. However, by this time he had been diagnosed with terminal bladder cancer and was not expected to live. In August, the Supreme Court said it would consider hearing Ellis' appeal even if he died before the hearing date, the 11th of November. He died on the 4th of September 2019 before the hearing began. Takanga issues prior to this hearing, which began on the 14th of November 2019, courts in Commonwealth countries, including New Zealand, have traditionally ruled that an individual's interest in any judicial hearing ends if they die. On Ellis' behalf, lawyer Robert Harrison has said the appeal should proceed because it was an issue of public importance and addressed a systemic issue in the justice system. Justice Joe Williams noted, "This very Western idea that on demise you have nothing to protect," pointing out that Takanga Maori held that an ancestor has even more reputation to protect. He adjourned the hearing for 5 weeks so that both sides could make new submissions addressing Takanga issues in the new year. Appeal granted on the 1st of September 2020. The Supreme Court granted leave for the appeal to be heard despite Ellis's death. The court said the reasons for their decision would be released along with their ruling on the appeal. Defense lawyer Robert Harrison commented, "I think it's fantastic news. If the Supreme Court has gone down that particular path, they're saying there's a value here that deserves to be respected, and it means that there is valuing in continuing the appeal." New allegations against Peter Ellis. On the 11th of November 2020, the appeal was adjourned amid allegations of a historic sex offense against Peter Ellis from 1982. The complainant allegedly first approached the police in 1992 or 1993, though there's no record of this. She made a complaint in February 2019, but the Crown was not advised of it until September that year, by which time Ellis had died and could not respond to the new allegations. The complainant's claims were supported by her sister. The Crown took responsibility for the delays and admitted that more could have been done to satisfy the court of the veracity of the new evidence. The Crown also said the new evidence had been sworn to, while Ellis's defense lawyer Robert Harrison commented that the new evidence had no reliability and expressed concern about its credibility. The court granted leave for the Crown to present its report on the new allegations on the 27th of November, 2020. On the 26th of March 2021, the Supreme Court heard the application for the woman's evidence to be used in the appeal. It has the statement of a woman who says Ellis babysat her and offended against her in a manner similar to that for which he was convicted of crimes committed against children at the Civic Creche in Christchurch in the early 1990s. The alleged acts against the woman happened long before the ones Ellis was accused of committing at the creche. She allegedly recognized the man who molested her as Peter Ellis from a 2007 documentary about his case. Defense lawyer Rob Harrison told the court that the evidence was not relevant to the appeal, and if the evidence was admitted it would expand the scope of the appeal to challenge its reliability through ACC and other records. He said there was no evidence to support the woman's statement and it was unfair to use it now. Ellis could no longer respond to it, and Ellis was given no opportunity to do so while he was alive. He also said the woman's statement was inconsistent with earlier recollections she had given, suggesting her memory was evolving. Crown lawyer John Billington admitted there were inconsistencies in the woman's statement and no corroborating evidence to support it. Nonetheless, he said the court must decide if the evidence was helpful in deciding the case. Given the nature of the case, is it evidence that this court considers would assist it in relation to the substantive issue that you have to hear in October? The court reserved its decision. The full appeal was set for October. Prominent support. Lynley Hood's A City Possessed. In 2001, Lynley Hood published a 616-page book about the case and the moral panic of sexual abuse within New Zealand at that time. In 2002, A City Possessed won the top prize for nonfiction and for Reader's Choice in the New Zealand Book Awards. As Hood tells it, fear and anxiety about ritual abuse began in childcare facilities overseas in the early 1980s. Given the number of sex abuse scenarios in Christchurch in the 1980s, such as the Glenelg Health Camp, Ward 24, and the Great Child Pornography Fiascos, it was probable that some sort of panic would break out in Christchurch. Hood argued that the professional careers of experts benefited from the case while more than 100 children were subjected to unpleasant, repetitive and psychologically dangerous procedures for no good reason. A former National Party leader, Don Brash, was drawn to the controversy after reading Hood's book. He commented, "I was stunned at how compelling a case it made. The Peter Ellis case is a serious miscarriage of justice and I am utterly astonished his conviction hasn't been overturned. It is implausible to believe 4 women and 1 man could do this in a busy creche." In 2006, Brash cited the case when supporting calls for an independent body investigating miscarriages of justice in New Zealand. On the 17th of December 2014, Brash and author Lynley Hood again called for a review of the case by way of an independent inquiry led by an authority from outside New Zealand. The appeal was made to Amy Adams, the newly appointed Minister of Justice for the National Party-led government returned in the 2014 general election. Journalist. According to Greg Newbold, senior lecturer in sociology at the University of Canterbury, even cynical journalists like Frank Hayden, David McLaughlin, Melanie Reid, George Balani, and Martin van Benen, the only journalist to have sat right through the trial, agree that Ellis is not guilty. Newbold notes that it was a politician who saved Arthur Allen Thomas, but the Ellis case is different from Thomas's because Ellis lacks government support. In 2000, after Ellis failed appeals, he wrote, "At the moment the judiciary is turning away from the plight of a man impugned by some of the most absurd testimony ever heard in a New Zealand court." New Zealand Law Journal in late 2007 and January 2008, 3 articles on the Ellis case were published in the New Zealand Law Journal. These included, "New evidence in the Peter Ellis case" by researcher Ross Francis. Francis concluded that despite 2 appeal hearings, 3 applications for a pardon, a ministerial inquiry, and a parliamentary inquiry, questions about the reliability of Ellis' convictions remain. He wrote, "Whilst it may appear that the case has been examined thoroughly, the facts show otherwise. The Court of Appeal did not review all the available evidence and, at the second hearing, failed to give any weight to the expert opinions." The journal review prompted Sir Thomas Thorpe to comment that the articles must add to concerns expressed previously that case may have gone awry. Notes. References: Bandler, Joy, A Mother's Story, The Civic Crash Child Sex Trial, Howling at the Moon Productions, 1997. ISBN 0-9583717-0-9. Sir Thomas Eichelbaum's report into the Peter Ellis case. Francis, Ross. New evidence in the Peter Ellis case, New Zealand Law Journal, November, December 2007. Hood, Linlay, October 2001. A City Possessed. The Christchurch Civic Crash Case. Dunedin, Longacre Press. ISBN 1-877-135-62-3. Justice and Electoral Committee Report. PDF. Lanning, K. 1991. Ritual Abuse. A Law Enforcement View or Perspective. Child Abuse and Neglect. 15 3. 171-173. doi:10.1016/0145-2134 91 90061 H. PMID 2043968. London, Carmel. Maggie Brooke, Stephen J. Ceci, Daniel W. Schumann, 2005. Disclosure of Child Sexual Abuse. What does the research tell us about the ways that children tell? PDF. Psychology, Public Policy, and Law. 11 1. 194-226. doi:10.1036/1076-8971.11.1.1.194. Retrieved the 26th of April 2006. McLaughlin, David. Second Thoughts on the Christchurch Civic Crash Case. Has Justice Failed Peter Ellis? North and South, August 1996, pages 54-69. Smart, R. 1992. A review of the management policy and practices of the Civic Child Care Center. Thorpe Report, Sir Thomas Thorpe, Auckland, March 1999. Transcripts of evidential interviews of selected complainant children. R.V. Ellis 1993. Peter Ellis Toddler Testimonies. See also Orkney Child Abuse Scandal. External links: Ellis Case, A Witch Hunt Against Victims, an August 2019 interview with a complainant's aunt. Peter Ellis page on crime.co.nz, peterellis.org.nz, advocacy site.